claiming this was self-defense without a complete investigation, especially when all the evidence of our senses would suggest if we're going to jump to a conclusion, we should jump to a conclusion that this was murder and not self-defense. But that's why we have the law. That's why we have a legal process. Now, the gentleman correctly states the situation, except he aborts the analysis midway. He says, well, she was told to stop, she was told not to go anywhere, but still, she drove her car away. And I certainly saw that. The Supreme Court has a decision just on this point, which I'm sure the gentleman knows. It was decided in 1985. Everybody in criminal procedure learns it. Tennessee versus Garner, 1985, because Tennessee had established.
Tonight on Capitol Hill, a heated and deeply emotional exchange unfolded in the House Judiciary Committee as Representative Jamie Raskin of Maryland took aim at President Trump and Attorney General officials over their response to the killing of a woman in Minneapolis during an ICE encounter. What made this moment stand out was not just the anger in the room, but the legal lesson behind it and the constitutional questions it raised about law enforcement power, accountability, and due process. If you want reporting that explains what's really at stake in moments like this, make sure you subscribe and stay with us.
Work right down the line.
Thank you kindly, Mr. Chairman. And I intervene here only because I want to respond to my friend from North Carolina, who I think starts with the incontrovertible point that it's wrong to prejudge whether this was murder. Then it is equally wrong to prejudge that it's self-defense. And I hope that that my colleague, with his astute prosecutorial understanding, would just as much reprove the Attorney General and the President for going out and claiming this was self-defense without a complete investigation, especially when all the evidence of our senses would suggest if we're going to jump to a conclusion, we should jump to a conclusion that this was murder and not self-defense. But that's why we have the law. That's why we have a legal process. Now, the gentleman correctly states the situation, except he aborts the analysis midway. He says, well, she was told to stop, she was told not to go anywhere, but still, she drove her car away. And I certainly saw that. The Supreme Court has a decision just on this point, which I'm sure the gentleman knows. It was decided in 1985. Everybody in criminal procedure learns it. Tennessee versus Garner, 1985, because Tennessee had a statute which said if there is someone fleeing the police, they can be shot. And the Supreme Court said that's not the rule. They can only be shot if they're fleeing the police if the police have probable cause to believe that the suspect poses a significant threat of death or danger to other people. Now, Ms. Good, who's a 37-year-old mom of a 6-year-old boy, now orphaned by ICE, posed no threat to anybody. At least, as far as we can tell, there's no suggestion that she posed a reasonable threat to anybody. That's the legal question. Now, I think our committee should launch an investigation into this. This would be a worthwhile subject for us to get into at this point. But the idea that simply because she disobeyed an order that she can be shot in the face at point blank is wrong. That's not the law in the United States of America. And you know who knows that? Everybody on this side of the aisle who talks about Ashley Babbitt. Because everybody talking about Ashley Babbitt seems to think that, well, she was told repeatedly to turn around and to leave, and then she still tried to use violence to get into our chamber, into the speaker's lobby, in order to get at us. And she was shot and repelled. And there were 2 different investigations which found that that was reasonable force used by the police because she was coming at them. But what we had in this case was this woman was trying to leave. She was trying to get away from it. She wasn't coming at the police. She was trying to get away from the police. So to the extent that we want to engage in an immediate post-mortem analysis, and I agree with the gentleman that this is why we have law. This is why we have a real legal investigation, and it is completely irresponsible for the president and the attorney general to be out there claiming against all evidence that this was self-defense. this is why we have law. Okay, then we should wait until we can make a final pronouncement upon that. But let's at least get down what the law is. This is the House Judiciary Committee. And people cannot be shot in the face simply because they walk away from a police officer. And especially when we've got police officers who are masked. And I just want to finish on this point, and I'm happy to yield to my friend. Because look, all of us represent jurisdictions. We've got local police, we've got county police, we've got state police. None of them are masked. We've got the Army, we've got the Navy, we've got the Marines. None of them are masked. We've got the National Guard. None of them are masked. Why is ICE masked? This is what we want to know. Nobody's given us a good answer for this. Now, one suggestion comes from the fact that we have multiple January 6 defendants who are working at the Department of Justice itself, including Ed Martin and Jared Wise. So if they're hiring them at the Department of Justice, presumably they're hiring them at the Homeland Security and ICE, and maybe they don't want them to be identified. Because, of course, those people were very well video documented on the day of January 6th. There's a lot of suspicion that that's why these people are being masked, and they're not even telling us why they're being masked. But it's precisely this episode which demonstrates why people are afraid of ICE and will try to move away from ICE rather than submit to their order, even when people need to submit to a lawful order of the police. Happy to yield to the gentleman.
Well, and just in terms of the masks, I think it goes without saying that there is an element of undue danger when you deal with international criminals. But in regards to the facts of this case, is it not relevant the angle from the officer's perspective? The only angles I've seen have been from hindsight, where the officer was who pulled the trigger, and I'll stipulate it was a tragedy. Is it relevant to see what he saw? He couldn't see that the wheels were turning, if they were. He couldn't see what where the trajectory was. He was right in front of the car that accelerated his direction. Is that not a relevant consideration to the ranking member?
Well, of course it's a relevant consideration. Yeah, I mean, if it comes down to a legal question, all of that is completely relevant. But what the administration is saying cuts completely against what we're able to see with our own eyes. Thanks.
The time of the gentleman's expired. The gentleman.
Raskin intervened after a colleague argued that it was wrong to immediately label the killing as murder. Raskin agreed with one critical point, that prejudging the outcome before an investigation is complete is wrong. But he said that logic cuts both ways. If it is wrong to assume murder, then it is equally wrong and just as dangerous for the president and attorney general to publicly declare the killing self-defense before the facts are fully examined. Raskin argued that the administration's statements ignored what many Americans could plainly see in available footage and reports. But he emphasized something even more important, that conclusions should not be driven by instinct or political loyalty, but by the law itself. And that law, he said, is clear. This is where Raskin shifted from outrage to education. He cited a landmark Supreme Court case that every criminal law student learns early on, Tennessee v. Garner, decided in 1985. That ruling established that law enforcement officers may not use deadly force against a fleeing suspect unless they have probable cause to believe the person poses a significant threat of death or serious physical harm to others. Simply fleeing, disobeying an order, or attempting to drive away does not meet that standard on its own. If explanations like this matter to you, subscribe now, because this legal framework is often missing from political debates. According to Raskin, the woman who was killed, a 37-year-old mother, posed no apparent threat to officers or bystanders based on the information available so far. He stressed that the legal question is not whether she complied perfectly with commands, but whether she presented a clear and immediate danger that justified deadly force. In his view, nothing presented publicly so far meets that threshold. He rejected the argument that disobeying a police order alone justifies lethal force, saying plainly that this is not the law in the United States. To illustrate the inconsistency, Raskin referenced how some lawmakers have defended the shooting of Ashley Babbitt during the January 6th attack on the Capitol, arguing that deadly force was justified because she was advancing toward officers and lawmakers in a restricted area. Raskin contrasted that situation with this case, emphasizing that the woman in Minneapolis was moving away, not advancing toward officers. This distinction matters, and if you value coverage that explains why legal details shape real-world outcomes, take a moment to subscribe. Raskin then raised another issue that is becoming increasingly controversial: the use of masked federal agents. He pointed out that local police, state police, the military, and even the National Guard do not routinely conceal their identities during operations. He questioned why ICE agents do, especially when they are operating within American communities. He warned that secrecy breeds fear, and fear can escalate encounters unnecessarily. When people cannot identify who is detaining them, they are more likely to panic, flee, or misunderstand what is happening, increasing the risk of tragedy. Raskin argued that this incident illustrates exactly why communities are afraid of ICE and why accountability matters. Throughout the exchange, Raskin repeatedly called for a full congressional investigation, not to score political points, but to establish facts, apply the law correctly, and ensure that deadly force is not normalized simply because an officer issues a command. Before yielding the floor, Raskin acknowledged that officer perspective is always a relevant factor in investigations, but he insisted that the administration's rush to label the killing as self-defense contradicted what could be seen and raised serious concerns about political interference in justice. If you want continued coverage that breaks down how power, law, and accountability intersect, don't forget to subscribe. This moment was not just about one tragic death. It was about whether constitutional standards still guide federal law enforcement, whether investigations are allowed to run their course, and whether leaders respect the difference between enforcing the law and rewriting it after the fact.